If you followed the P-Square controversy online, you must have seen the allegations around two entities with almost identical names, Northside Entertainment and Northside Music. Two names that are similar enough that money could flow into one when it was intended for the other. Before I proceed, let me just say that I am not here to litigate that dispute. What I want to talk about is the legal issue sitting underneath it. Because the question of whether someone can register a name almost identical to your business name affects every Nigerian entrepreneur, not just celebrities. Let us start with CAC. When you register a business name or a company at the Corporate Affairs Commission, CAC conducts a name availability search. If the name is identical to one that is already on the register, the application to reserve that name will be rejected. CAC has recently introduced AI screening on their company registration portal, which has made the process more thorough. The system can now flag names that are not just identical, but confusingly similar. But here's the thing, before this system existed, name checks were handled by human officers. And as the Northside situation has just shown us, similar names could pass. Northside Entertainment and Northside Music both made it onto the register. So because they are not identical, and at that time, that was enough. Even today, AI screening is not foolproof. If one could come up with a creative variation, a slight spelling difference can still produce two names similar enough to cause confusion. And every business registered before the AI system existed is operating in an environment where similar names may already be on the register, sitting there quietly until someone exploits the similarity. So what does the law do about it? Let me just say now that just because CAC allows similar names to coexist does not mean that using a confusingly similar name is legal. Nigerian law recognizes a tort called passing off. Passing off happens when one business misrepresents itself in a way that causes the public to confuse it with another business. To succeed in a passing off claim, you need to show three things. 1. Your business has a reputation that the public associates with your name. 2. That the name or branding of the other party is likely to confuse the public into thinking that they are you or connected to you. 3. That you are suffering or you are likely to suffer damage as a result of that confusion. In the context of similar business names, if someone registers a business name so close to yours that clients, partners, or the public could reasonably mistake them for you, you may have a claim in passing off. And if money has gone to them because of the confusion, that damage is exactly what a passing off claim is designed to address. But here's the honest truth about passing off. It is a remedy that kicks in after the problem has already happened. What you really want is something that prevents the problem entirely. That is what a trademark does. CAC registration protects your right to operate under a name. It does not protect the name itself as a brand identifier. Only trademark registration does that. A registered trademark gives you the exclusive right to use that name or mark in the classes under which you registered it. And it gives you the legal standing to stop others from using a name or mark that is identical or confusingly similar to yours. With a registered trademark, you do not have to wait for confusion to occur and then prove damage. You have a registered right you can enforce proactively. Without one, you are relying on passing off, which is harder to prove, more expensive to litigate, and only available after the damage has already been done. The P-Square situation, whatever the full facts turn out to be, illustrates a vulnerability that is not unique to celebrities. Any Nigerian business that has built a recognizable name without trademark protection is exposed to the same risk. And your only remedy is a passing off claim which requires you to prove goodwill, misrepresentation, and damage in court over time and at a considerable cost. So if your business has a name, a logo, or a brand identifier that the public associates with you and you have not registered it as a trademark, someone can register a confusingly similar name at CAC tomorrow. Or worse, they can trademark your name before you do. And at that point, you may be the one who has to stop using it. Prevention is cheaper than litigation every single time. Before you leave, if you have a brand name, a logo, a slogan, a sound, a color combination, just anything your business is known by, take steps to have it trademarked before you hear stories that touch. And if this helped you in some way, subscribe to Goga's Brief. I'm Goga, and I'll see you in the next one.